Thank you for inviting David and I to speak about the family law issues you and your clients really need to know when moving between South Africa and the UAE or Australia. Given that our presentations are pre-recorded and prepared, we appreciate that it is different to us being there in person, and that there is no scope to ask us questions along the way. However, both our contact details are on our slides, and please feel free to get in touch with one or both of us in relation to any questions you might have. In our experience, so often when people decide to relocate, they're focused on the appeal of an expat life and the practicalities surrounding their move, such as where they're going to live, where their children are going to go to school, and so on. But more often than not, no thought is given to the potential legal implications of where they are moving to. It is only when relationships break down post-relocation that this comes to light, often too late. This is particularly true of the UAE, which I am going to focus on. My colleague Pt.1, who is dual qualified in England and Australia where he lives, is going to focus on Australia. We're going to talk about how the laws differ in these countries and how this impacts the advice that you give clients who may or have immigrated. There is a lot of detail in these slides, which is deliberate, so that they are a helpful reference point. I don't intend to go through all the detail, but to focus on what I think are the key and interesting points. In terms of background, it is important to remember that the UAE is only 50 years old and is constantly evolving. There is a natural conflict between the conservative Sharia laws and the ever-increasing number of expats from different cultural backgrounds. This has been challenging for both Emiratis and expats alike, but times are changing and there have been sweeping changes to UAE family laws over the past few years. Historically, UAE family laws were developed from Sharia laws and principles. Amendments to the main personal status law were made in 2019 and 2020 in order to enable expats to undertake a divorce more in line with their own culture. These provisions apply across the UAE, apart from in Abu Dhabi, which has made its own changes and introduced a new civil family court aimed at the expat population. As such, the divorce process and financial outcome for non-Muslims is now different in Dubai and Abu Dhabi, with different rules being applied depending on whether an individual is Muslim or non-Muslim. I will come on to Abu Dhabi later. However, turning to the UAE changes first. The new position is that expats can divorce in the UAE using the laws of the place in which they were married. These laws will apply to the divorce and the associated financial claims on divorce. In terms of the divorce process, the UAE courts will look to the laws of the place of marriage. For example, in England, as is the case in South Africa, there is now a no-fault divorce procedure which the UAE courts would look to. In terms of parties with the South African ANC, this will be recognised provided the parties married in South Africa. However, whether it will be interpreted accurately is another question which I will come on to. In order to understand what this change means, it is necessary to briefly consider the previous position. Historically, expats could ask for their home country's laws to be applied by the UAE courts, so long as they were both citizens from the same foreign country. Where the parties had different nationalities, the law of the husband was applicable. However, in reality, foreign laws were rarely applied, as the UAE courts still had discretion to apply UAE laws in a situation where the home country laws did not fully cover certain aspects of divorce or were not readily interpreted, meaning cases often had a Sharia law tilt. Also, the application of foreign laws were blocked if their principles conflicted with Sharia law or public morals. In light of the recent changes, foreign laws are no longer blocked if their principles conflict with Sharia law or public morals. Under Sharia law, broadly speaking, a wife is not permitted to seek a share of assets in her husband's name, and spousal maintenance limited to 3 months. With the removal of this restriction, it is hoped that orders could be made for sharing of assets and longer-term spousal maintenance. While this development was welcomed and provides a clearer and hopefully fairer position for expats, whether the law of the state where the marriage was concluded will be interpreted accurately by the UAE courts is another question. As was previously the case, the application of foreign laws can be difficult, time-consuming and costly, as all applicable laws must be translated into Arabic. This is virtually impossible in English law cases, given the volume of English case law that would need to be translated. It is potentially more achievable in South African cases where there is a straightforward ANC, but is by no means easy. Also, UAE judges may have difficulty applying the relevant laws, which again is likely to lead to them adopting a Sharia law tilt. It is also problematic where parties are married in a different country to where they are from. For example, where the parties are South African and have a South African ANC, but married in, say, Mauritius. According to UAE law, the applicable law would be that of Mauritius. It is not clear how this would be resolved, but I would be nervous about pursuing such a matter through the UAE courts. It is also important to be aware that very rarely would the UAE courts cease proceedings if proceedings are issued in the UAE and South Africa. Instead, the UAE courts usually go full steam ahead to process divorce so that there is no marriage to dissolve in the UAE. While you could try to prove that proceedings are underway in South Africa, notarized, legalized copies translated into Arabic would need to be put before the UAE courts, which would take time and is costly. In terms of tips, I would advise clients who are relocating to the UAE other than Abu Dhabi not to get married there. Even if they have a South African ANC, the applicable law on divorce will be the UAE, given that is where they married. Where clients are relocating from South Africa to the UAE, it is worth considering registering their South African ANC with the relevant UAE court. This cannot be done prior to marriage, but can be done after, and would increase the chance of it being upheld. Where parties have reached an amicable settlement agreement in respect of their divorce and finances, this can be registered with the UAE courts, and the UAE courts can be a good option in those circumstances. However, where matters are likely to be contested, we would generally advise steering clear of the UAE courts, albeit advice might differ depending on which party you are acting for. In terms of traps, one very important consideration to bear in mind is that the UAE courts only deal with assets in the UAE and do not make orders regarding foreign assets, which can be problematic for expats who have assets overseas, the only exception being where parties consent. Foreign pensions are also not recognised. Another trap which we have witnessed many expats falling into relates to adultery, which remains illegal in the UAE. I will address this in more detail in the context of children. However, the bottom line is that criminal proceedings in the UAE should be avoided at all costs and should not be used by an aggrieved party as a method of revenge, as is so often proposed to us by our clients. Perhaps the hardest difference to fathom between the UAE, apart from Abu Dhabi, and countries like South Africa and England, is the approach taken to children, as despite there being provision for matters related to guardianship and custody to be governed by the law of the person whose protection is required, we have only ever seen the UAE courts apply UAE laws when it comes to children, unless parties have reached an amicable agreement between themselves. In short, mothers automatically become the custodian of young children, meaning they are responsible for their day-to-day care, and fathers are the guardians, meaning they make all decisions regarding a child's religious and educational upbringing and medical treatment, but they have limited contact rights, i.e. parents do not share equal parental responsibilities and rights. There's also automatic provision for custody to move from the mother to the father at age 11 for a boy and 13 for a girl, albeit this can be challenged if it is in the best interests of a child. There is also no legislative overriding principle of the best interest of the child, nor is there any provision to allow a child to be heard. There is also no equivalent of the Office of the Family Advocate or provision for the involvement of an independent social worker. When determining custody issues, UAE courts do consider the welfare of the child as the primary concern and make a decision based on a child's best interests in each particular case. However, this still sits against the backdrop of having a separate custodian mother and guardian father. In terms of travel, the guardian is entitled to hold his children's passports. Both parents should seek consent from the other to take their children out of the country and can seek a travel ban if they are concerned that their permission will not be sought. One of the biggest issues we see expats face in the UAE is relocation, usually where a marriage is broken down and one party wishes to return to their home country. The custodian of a child may not permanently settle a child in another country if it would cause harm to the other parent, or if the distance between the two countries prevented the non-resident parent from visiting the child and returning home in a day. Conversely, the guardian may take the children to live abroad permanently, as long as the reason is valid, such as the loss of employment. As such, unless the father consents to relocation, a mother's application is highly likely to fail unless there is a strong welfare argument. One such example is where a child needed life-saving medical treatment, which could only be done overseas. In terms of tips, it is important to advise clients who are relocating to the UAE to consider entering into an agreement with their spouse or partner before they move, which provides for their children to be permitted to relocate to South Africa in the event the marriage or relationship breaks down, and for the mother to hold the children's passports when acting for the mother. While this would not enable relocation, it could help persuade the UAE courts to lift a travel ban and could be used in support of an application for relocation. However, it is imperative that clients understand the very real risk that children might not be able to relocate from the UAE if the marriage or relationship breaks down. Where parties reach an amicable agreement in relation to their children's arrangements, it is possible to submit this to a court in the UAE to be confirmed by such court so as to be enforceable locally as a judgment of the UAE court, but this does require the parties to cooperate. Similarly, a mirror order can be obtained where parties agree, which is advisable in cases where children might travel to UAE to have contact with a parent. Either way, it is also advisable to include an agreement that the mother's remarriage will not impact the arrangement, as otherwise this can unravel things. In terms of traps, in addition to a parent making false allegations in respect of the other parent, we have seen parties, usually fathers, converting to Islam, as under UAE law, the mother can lose custody of a child as young as 5 if she does not bring them up in the same religion as the father. This is applied more strictly when the father is Muslim. Also, a custodian must not have been sentenced for a crime of honour, for example, adultery. We have acted in 2 high-profile cases involving allegations of adultery, which I have set out in the slides. The first was a case of Marnie Pierce, a 46-year-old British mother of 2, whose Egyptian husband claimed she was having an affair, which resulted in her being convicted of adultery, jailed for 3 months, and losing custody of their 2 sons. Miss Pierce claimed that her husband made up the adultery claim to win custody. She then went on to allege that it was actually him who was having an affair, and that after she found out and threw him out of the house, he planted used condoms in the house and organised a police raid. This made headlines around the world. As did the case of Sally Antia, who was actually having an affair, and her husband tipped off the Dubai police, who then found her in a hotel with her lover, as a result of which she was imprisoned for 2 months and then deported. He did this in order to win custody of their 2 daughters. In a surprising twist, her husband subsequently had a change of heart, and after her deportation, they relocated to Australia to try and rebuild their marriage. I personally can't imagine trying to reconcile with my husband if he had me imprisoned, but needless to say, adultery in the UAE is not a good idea. With regard to child abduction, as I'm sure you all know, the UAE has not signed the 1980 Hague Convention on the civil aspects of international child abduction. As such, there's very little that can be done to secure the return of children from the UAE to South Africa or another country. Interestingly, the English courts have dealt with numerous cases where a child has been abducted from the UAE to England and whether a child should be returned, given the lack of provision in the UAE for relocation applications. However, this is a topic in and of itself and not for discussion today. Moving on to Abu Dhabi. The law in Abu Dhabi recently underwent considerable change, announced one day in a national newspaper, and thereafter existed a cultural revolution for the largest emirate in the UAE. The new Abu Dhabi laws are aimed at the expat population and apply to non-Muslim expats and can apply to Muslim expats apart from those from certain countries. Jurisdiction is mainly based on residence in Abu Dhabi or having an existing or previous working address in Abu Dhabi. This inclusion of working addresses widens the scope and helps expats who may live in Dubai but work in Abu Dhabi, or who worked in Abu Dhabi and then moved to Dubai. In summary, now non-Muslims can easily get married in Abu Dhabi, plus they can access a new no-fault divorce procedure with court forms and procedures in Arabic and English, and court proceedings in English. Divorce can be obtained quickly with provision for it to be granted at the first court hearing, which is scheduled 30 days from the date of filing the application. The table on the slide is an extract from the new Abu Dhabi Civil Family Court website, which shows how the new no-fault divorce is different to divorce under Sharia law, as well as the documents required to support the no-fault divorce application, which, in addition to the marriage certificate and ID, includes their employment contract and last 6 months of bank statements for all accounts. The idea behind the new Abu Dhabi Civil Family Court is that parties cannot request to have the laws of their home country applied, and that the new Abu Dhabi laws will apply. I mentioned in my slides that it is not yet clear how foreign ANCs will be interpreted. However, we contacted the Abu Dhabi Judicial Department for clarification, and their response was that the court will enforce a prenup agreement, regardless of where it was issued, which is promising, albeit as far as we are aware, this has not yet been tested, and we simply have an email confirming this, rather than there being specific provision for this in the new Abu Dhabi laws. Where parties do not have an ANC, the new Abu Dhabi laws will apply. Broadly speaking, in relation to capital, the judge may compel either spouse to pay a lump sum to compensate the other, taking into account a number of factors, including the length of marriage, ages of the parties, standard of living, health and financial resources of the parties, contributions, needs of any children, plus the fault of the parties and moral and financial harm. The court may also appoint an accounting expert to assist in evaluating the financial status of the spouses, and there are 3 criteria set out to assist in calculating the financial value due after divorce, being no less than 25% of the husband's last monthly income times by the number of years of marriage, a percentage of the husband's property and wealth, plus consideration of joint money between the spouses and the extent of their participation in it. In terms of maintenance, the provision is very one-sided, in that a father is obligated to pay housing support to his ex-wife for the duration of the joint custody of the children, unless the ex-wife is able to rent or own suitable housing herself, plus maintain his children after the divorce, including their education, residence fees, treatment, and other daily or periodic expenses that he paid before the divorce. There is no equivalent provision for mothers to pay maintenance. It is also unclear at this stage how far housing support extends. Where there are no children, there is provision for housing support for a temporary dwelling after divorce, plus temporary spousal maintenance until the financial rights are decided. In terms of tips, as with the other UAE courts, where parties have reached an amicable settlement in respect of their finances, a settlement agreement can be submitted to the Abu Dhabi Civil Family Court for approval. There is a specific form which should accompany this. There is also a set application form for making a financial order, which requires parties to set out their income, expenses, assets and liabilities, plus the orders sought. It is akin to the English Form E, but is less detailed and does not have the same supporting documentation requirements. There is also an application for freezing capital until the export report is issued, which could be helpful in some cases. All forms can be found on the Abu Dhabi Civil Family Court website, the link for which is in my slides. In terms of traps, while the developments have been applauded, many gaps still exist, and much progress remains before Abu Dhabi is likely to stand as a forum conveniens as against England's, save for where English expats have entered into a prenup, in which case it would depend on the terms of that prenup and which party you were representing, given that the prenup would not automatically be enforced if the parties were to divorce in England. In comparison, given that it is the norm for South Africans to enter into an ANC, in light of the fact that the Abu Dhabi Judicial Department have said that they will enforce foreign prenups, Abu Dhabi could well be an attractive option for South African expats who have an ANC. Where parties do not have an ANC, shortfalls in the new Abu Dhabi laws include the lack of procedural rules regarding disclosure and the absence of a general duty of full and frank disclosure. It is also not known if there will be a concept of matrimonial property and sharing, or if the Sharia law principles will continue to endure with regards to capital. It is also unclear if there will be a more in personam style order in relation to foreign property, which enables the transfer of property based anywhere in the world. Plus, the divorce is granted before the finances are dealt with, which could be problematic in the event one party dies before the finances are resolved. A very welcome and radical change relates to children, namely that the default position in Abu Dhabi on divorce is now joint custody between a mother and father until a child is 16, when the child can choose. As such, parents have joint responsibility for major decision-making, plus equal or close to equal time with both parents. Parents are encouraged to try and agree the exact arrangements themselves, but the court will do so if necessary. Either parent can object to joint custody if, for example, there is risk of a child being exposed to domestic violence, or there are inadequate living conditions, and so on. The other party's remarriage is also detailed as a potential ground for objecting to joint custody, and is something to be mindful of. The position into travel and relocation remains similar to the position in the remainder of the UAE, and therefore remains problematic for expats. It is hoped that this will be addressed in due course. One exciting development is a provision in the new Abu Dhabi laws for spouses to agree to use arbitration to resolve family disputes, either through a single arbitrator or an arbitration panel. This is illustrative of Abu Dhabi's desire to be progressive. I wanted to briefly mention enforcement, as we frequently encounter difficulties trying to enforce foreign orders in the UAE, where a party resides in the UAE and refuses to adhere to the terms of a foreign order. Previously, the UAE courts could refuse to enforce a foreign order if they considered that they had jurisdiction over the matter resulting in the foreign order. Now the UAE courts can only refuse to enforce a foreign order if they have exclusive jurisdiction. Also, as a result of changes announced in September, highlighting the principle of reciprocity initiated by the English courts in a recent English commercial law case, we are hoping that it will become possible to enforce English law court orders, with this hopefully extending to other countries in due course. We are currently liaising with a local UAE law firm to see if they will take on a case of mine as a test case. We will have to watch this space. At present, there is no provision in the new Abu Dhabi Civil Family Court regarding enforcement of foreign orders, but again, it is hoped that this will be addressed in due course. A helpful tip where you envisage that enforcement in the UAE might be necessary is to include in the recitals of any South African order the UAE enforcement criteria detailed on my slide. Lastly, I've included some information about visas, which is self-explanatory. The most important thing to note is that there is provision for divorcing couples to be allowed a 1-year visa post-divorce to enable the non-working party to obtain their own visa. As I said at the outset, please do not hesitate to get in touch if you have any questions. I appreciate that my presentation is a bit of a whistle-stop tour of the new UAE laws. The most important takeaway is that it is imperative that South African clients who are considering relocating to the UAE or who are living in the UAE and contemplating divorce, whether amicable or not, take legal advice from a South African lawyer and either a UAE lawyer or lawyers with UAE expertise in advance and are aware of the risks. Our firm has a branch office in Abu Dhabi headed up by Byron James, who is renowned for his UAE expertise. Our managing partner, Alexandra Tribe, is also frequently asked to provide expert reports on UAE family law matters for numerous different countries. We are also hosting an International Family Law Conference in Abu Dhabi in April next year, which will cover in more detail the changes I have discussed today, as well as other international family law topics. If you wish to know any more, please do not hesitate to contact me. Enjoy the remainder of the conference.